welcome ladies and gentlemen for coming here. I think we've had the benefit of some very excellent speeches, especially by Mr. Kemawat as well as Mr. Sundaram and the co-founders of LawWiser. The LawWiser initiative is quite laudatory because it puts the data first. As a law firm partner, I appreciate that because you have a lot of GC conferences which are without data, which are just commemorations of general counsels, of law firms, award shows. But I do like the approach of LawWiser to put the data first, who's doing what, why do you select counsels. So what we'll try to do on this panel is dive into this data. In fact, I found one very interesting aspect of Mr. Gemawat's speech where he mentioned that general counsels are not recognized enough by the Bar Council. This, of course, alludes to the problematic issue of being an employee, as Mr. Sundaram also mentioned, of a company and not being treated as a counsel. For instance, in the UK, you would remain a solicitor even in the employment of a company. But interestingly, as we found out last year, even law firms are not very well recognized by the Bar Council of India. So they went ahead and created a circular for bringing in foreign law firms into India without any prior consultation of law firms in India. So you do have this tussle for corporate lawyers generally. So without further ado, what I'll do is I'll just throw some questions at this very distinguished panel right here. So the first question that comes out in the context of this data is that proven expertise is the #1 selection factor for any counsel. Any external counsel is based on proven expertise, and this is followed by prior relationships and cost effectiveness. So none of this is very surprising as such, but what did come out as slightly surprising to some of us is that referrals within the GC network remains the most important source to assess these criteria. So if some firm is cost effective or not, if some firm or their partners have proven expertise or not, GCs use their own networks to find this out and figure this out. So Parvesh, what is your view on this? Do you use social media a lot, and do you work on this a lot?
So before I touch, give the answer or my thoughts on this question, let me first congratulate LawWiser and Aman and Lavanya and the entire team of LawWiser. In fact, though I keep on meeting both of them and discussing on various aspects on the GC's role and and conducting these kind of programs. So, and we keep on attending various conferences like this of the lawyers, as Avimukt told that those conferences are generally without data, and here we are discussing something that they have conducted the survey and then making us meet here. So they conducted the survey on lawyers' expectations or the general counsel expectation from the law firm, and then bringing us on the same platform that where law firms and GCs are meeting with each other and conveying our thoughts, right? So this I will come to that how we select that. And I will say these kind of events are typically, what can I say, the hatke events, right, Aman? We were discussing earlier also, because here we are not discussing just subject which we keep on discussing on various forums, but we are discussing those things which are the pain points from GC's point of view, and on the other side, our expectation from law firms, and yes, law firms' expectation from us as well, right? So the kind of survey was conducted from the lawyers, but there may be certain law firm expectation from the GCs. In fact, I remember that in the last year when we were discussing on panel, one of our co-panelists suggested that expectation of law firm from the other law firm as well, like those ethical practices of the law firms which they expect from the other law firms while exchange of if there are few clients are changing or they are leaving the firm and starting their own. So bringing the general counsels here and discussing on those issues is remarkable, Aman. Once again, congratulations to the team here. So coming to the question that whether how we select the law firms and whether referrals plays a good role in selecting the law firms or not. I can take it in this way that being a general counsel, what kind of work I have to offload or I have to outsource to the law firms, right? Generally, I always believe the in-house capabilities which I try to bring in my system. But being a high-stake matters where you have to outsource the work. So the outsourcing of work generally comes in two aspects. One is litigation, and on the other side, I generally outsource the corporate advisory works to my client, to my lawyers. So in the litigation, again, there are few high-stake matters, and the and the general routine litigation. So routine litigation, I always try to refer to the youngster in the system, so that the youngster can get that chance to deal with the good organization, big organization. Otherwise, it is always difficult to youngster to prove themselves or to come in the market. That part is over. But if I go for the high stake litigation, there I have to see what expectation I do have from the law firm. That helps me to select the law firm, right? Either the high stake litigation or the high stake M&A matters or the advisory matter. There I understand that I need the law firm with the proven expertise. That is one. Secondly, I have to see the cost as well. Two. Third, I will say that the timely deliverables by the law firms. And I will take the fourth point, that the accessibility of the partners or the team which is working for me. These are the 4 criteria I have to see while selecting a law firm. So if I go with the proven expertise, what proven expertise is for me? Like I will say that proven expertise is that being a general counsel, if I find myself as a business lawyer or business enabler lawyer, so I expect the same thing from my law firm who is helping me. That proven expertise does mean that they are the business advisor, they are my strategic advisor, they are my business partners, and yes, they are helping me at every point when I need their help. So these are the few things I see in the law firm which I am going to hire. So how I can find the proven expertise of the law firm? Their referral works a lot. Like proven expertise, how I can come to know that the individual lawyer or the law firm can help me on the specific things which I need then. So it may be either through my previous relations, that is one. So if I have my previous relation, I already worked them, so certainly I know that they are good in particular subject and that can help me. Two, maybe referrals. So how referrals work, like I have to get the referrals from my peers, like from my industry friends. And that's the point I was telling Aman, arranging these programs help me to get the referrals. So these 100 GCs sitting here are good friends of mine, and I can even touch any time with a phone call away and can find good lawyers, either calling them, either in one message away, they can suggest me. So that is the one referrals helps me. So on this aspect, I find these 2 points, that expertise through referrals. Coming to 2 other aspects which I told you, cost and availability plus timely deliverables. Cost is the other aspect where we find that how we can get the lawyers on board. Like, cost is not always a challenge, but yes, for a GC, so it's a challenge for us to deal with that. So we need the value for money which I am giving to the lawyers. So ultimately that also comes from the referral. If I have not worked with any of the law firms, ultimately my aim is that value for money should be there. And that law firm junior team should not be trained on my money. So that is the other aspect I always see in the law firm which is helping me. Third is the 2 aspects which I always give a weightage, high weightage to that. One is availability and timely deliverables. So if these 4 aspects are there, so either through my previous relationship or referral, I always go with that. So referrals plays a good role to hire the law firms in system.
Thanks a lot, Parvesh. In fact, now I will switch to Simranjeet because he is a litigator. Now, when we all started out, now referrals, what we call referrals today would be called word of mouth. That everybody has a goodwill based on word of mouth. There was no WhatsApp, of course, but there was word of mouth. But one of the ethical questions which used to come up, right, and was always that, and I see this a lot amongst lawyers, including lawyers in my own firm, that people often ask their clients, hey, can you refer me some work from your contacts, from your other GC friends? Now, as a litigator, it's obviously maybe harder because of the way that the litigation bar is structured. So how do you crack this problem that we see, or this challenge we see, that 76% of these sources are referrals? And do you think senior counsels as well as arbitrators play a role, because even their recommendations would have an impact within the fraternity?
Yes, they have a significant role when it comes to referrals. But at the end of the day, the fact of the matter is that if your product is good, any person will ensure that they are going to take up that particular organization which is going to be able to deliver the end result. Now, when it comes to referrals, I guess from the GC's perspective, what happens is that they basically look at it from the perspective of whether or not a person is going to be able to get you the result that they so desire. Now, if you're able to do that, that basically instills trust in the organization itself. And if there is trust which is gained by the concerned person, what it then leads to is a situation whereby you are going to be referred to a different client by the concerned general counsel. As far as senior counsels and arbitrators are concerned, certainly they basically would refer you on the strength of the work that you have done, because that is crucial. At the end of the day, if you're not able to execute the work, then there's no point in any person referring you, because even a general counsel will not stick his neck on the line to say that, okay, fine, I'll refer A, while he knows that the person will not be able to execute the work. So at the end of the day, it is, for me, the product speaks for itself. It is crucial that you are able to execute the work properly. And that is why the data speaks for itself. It says proven expertise. So if you have the expertise, that's when the referrals will automatically start coming, not only from the general counsel side, but also from your peers within the organization, senior counsels, arbitrators, your own colleagues. Further, at times we also, as lawyers, refer certain work to different law firms, wherein let's just say that we don't have an expertise. Like in regulatory matters, there would be certain people who would be having the expertise in a particular field, like electricity law, telecom. All these things are extremely technical. And as such, we at times also refer to certain other colleagues of ours who are basically dealing with those particular fields specifically. So as such, we also refer matters to other people, as well as the general counsels doing so in their own ways.
Fantastic. That's very useful. One of the factors which come up, right, and I think Parvesh also mentioned this, that if the matter is not very complicated, not a high stakes matter, I'll go to a youngster. If it is very complicated, very high stakes, I'll go to an older, more experienced person. So one of the issues which is coming up for law firms generally is also sectoral expertise, right? So every general counsel in this room belongs to different sectors. Some of you have 3 or 4 sectors under your belt, right? Depending on whether you're youngsters or oldsters. So in that sense, law firms also, even though we've been trained always to focus on law, need to focus on sectoral expertise. This becomes important not only in M&A transactions, but also even in litigation. Because even in litigation matters, sometimes you have sectoral overlaps. So, and that could be something which can bridge the old-young gap, which is there. Because if you have a sectoral expert who is not that old, at least he or she has that bench experience that is there. So, what do you think, Mr. Gupta, since you come from a very interesting sector in Jubilant, so how much importance do these 2 things work for you? One is, as Mr. Arima Sundaram mentioned, commercial understanding, the commercial lawyer, and the other one is understanding of your industry itself.
So, good evening. There are 2 parts, and I'd like to answer it in further 2 parts. One is, what is the sense I get when I talk to counsels in India, and what is the sense I get when I talk to counsels outside of India. Generally, the deal starts or the interaction starts on a very characterized or compartmentalized thing. Okay, I'm doing a M&A deal, so I'm looking at a counsel. I select a counsel, but then what happens next? That is where the problem starts. So when I go deeper, for example, I was doing a R&D site acquisition of an R&D site in Europe. And now I selected a law firm more so on their expertise in terms of the M&A capability or expertise which was demonstrated, referred and all that. But when I went into the details, and I'm not criticizing the law firm or the lawyer involved, they were having no clue what an R&D acquisition would entail. So normally an R&D acquisition you would go to, it would involve IP, it will involve so many other things, people skills, scientists and so on and so forth. It's not like a normal acquisition. So the commercial part here becomes important, and the lawyers had no clue that if I am acquiring a site, so they gave me good advice, site, facility, equipment, everything else, but nothing in relation to the R&D part of it. What are the R&D programs? How will I continue? How will the transition happen? What are the laws in Europe around those challenges? So the commercial aspect was totally missing. Now the next step, and I think the other speaker also covered it, is do I pay for their training? Do I pay for the law firm coming up to speed on those commercial aspects, which becomes very difficult. So the law firms also want to invest, but then they are also not sure that if I have a next deal, will I go back to them or not? So they are also in dilemma. Do I invest in this client or not? And then if they invest, what is the surety that the GC or me, for instance, as a GC, will go back to them? So I think that that is problem is also there. And a lot of the comments made by Mr. Sundaram were on the commercial aspects were resonating with me, like the commercial aspect, the business aspect. I think in law firms also, so for example, in this particular case, the team which was involved were those who were having expertise in M&A. But their IP team, maybe I should have briefed them properly, or maybe they should have taken the cue that, look, it is a going deeper into the M&A transaction, what it involves really. So same is with litigation also. So we go to a counsel who may have good rapport with the bench, with all the theoretical which needs to be done. But when it goes into the issue, some only have that expertise to get into the issue, and which is where I think our role comes in, that we are able to explain to them that what it really involves and the strategy part. So, and the third aspect, I'll just say commercial or industry expertise, again, it's also evolving. So when I look at my organization, today I may be interacting with you about where my state of organization is. So I am doing pharma, tomorrow I am planning to do nuclear pharma, or I am planning to do radio pharma. Now, would you be willing to invest time in that? When I also don't know that my product will eventually see the light of the day or not. I am doing 10 different technologies. Generally, the success rate is only 1%. So if I ask you to invest in radio pharma, I am also investing my time. But what if the stage 2 trials are not successful? Then what happens? So those are some of the commercial challenges which we are facing. Some law firms are more forward thinking, long term, and therefore they are willing to invest. Some are not. But then the only other message I want to say is it's across. Even US law firms, European law firms are having the same problem, dealing with companies who are especially in the technology space.
No, actually, that is a very valid point. In fact, it goes back to, if I may say, especially in Indian market, the experience level of the external lawyer concerned, right? We've often seen then when the M&A lawyer is not very experienced, they're more than happy to dip into the firm resources, go to an advisory lawyer, for example, an IP, and take their inputs so that the client gets the best service possible. And of course, you have to divide up the mandate accordingly, and the law firm has to have that culture. But if you have very experienced M&A lawyers, often they say that they understand everything. They understand labor and employment, they understand IP. So sometimes that approach can become counterproductive in very specific areas. And you're totally right. If it's a very niche sector, chances of getting another deal is harder. But the advisory team of the firm, if they're plugged in, they will actually be excited to explore that niche sector as opposed to M&A lawyers. Which brings us to the next question, which is about cultivating relationships. So this survey reveals that general counsels are ready to pay premium if it brings the comfort of having worked with the partner before. and the assurance that they will get the service they need, right? So far, so good, not unsurprising. But the issue is, how do you cultivate that relationship as the lead partner, where you feel that the general counsel will continue to come back to you and not feel that he or she is dealing with a faceless organization, where any partner can be assigned to any matter randomly. There is no lead partner. So, Sanjeev, what is your view in seeing how to always position that you are for the client first and maintaining relationships and cultivating them?
So when I speak of this, I think that would be true for most firms. Nowadays, all firms are aware of this requirement that there has to be a personal relationship with the client, and it can't be, like you said, that matters are being passed off from one partner to other. We are all looking at building relationships with the client. That only happens if one partner is handling the matter for a long term. So that is a given. And I was also hearing about the cost concerns regarding GC, although that is not the question, but I'll just say, being a litigator, one thing, sir is here, one thing is guaranteed in our legal system is we know that the matter will not end soon. When it will end, nobody knows. And the problem with our system is, I don't know whether I should be saying this, is nowadays we have this interim relief kind of thing. In India, matters get delayed for so long that the client comes to me, is only aware or mostly is concerned whether we are getting the interim relief, because once you get that interim relief, it effectively becomes the final relief. So that is where the face value system has come in. Once again, with senior counsels, you get that benefit of a hearing before a bench. The bench may not hear me in that detail as it would hear Mr. Sundaram or Mr. Sehgal. There are face values. If this interim relief business is, or at least somehow managed, then we get into the merits of the matter. Then I don't think it makes much of a difference who's arguing the matter, so long as he's arguing the matter effectively. But since the judges have extremely heavy docket, they don't have the time. So nowadays, client and the GCs also, they are aware that if they want the court to even entertain your matter for a sufficient amount of time, you have to have a GC. So that invariably raises the cost. So it is a peculiar situation. You are concerned about the cost also, but invariably in these matters, the GC will say that we need a very high profile senior. So it can't work both ways. So until it has to be, there has to be a complete revolution in the way in which we litigate. Otherwise, there are delays which are endemic. The cost of even the law firm, the way we charge, the senior counsel, the way they charge, it is all prohibitive. Nowadays, we are all aware. The normal individual can't even afford a law firm, leave aside a senior lawyer. So these are issues. It suits me as a partner, but it also sometimes pains. I think I can speak with other litigators also. Nobody wants to hear a client cribbing, and we also feel that. You go to court, the court doesn't hear the matter, and you can't do anything. The judge has 80 matters, the other side will ask for a password, knowing the fact that the matter will not subsequently reach. And then the date is given after 4 months. If I was the client, I will be very aggrieved. But I know I have spent a sufficient amount of time preparing for the matter. Similarly, a senior counsel would be well prepared. Nobody comes to court without preparation. So he is given that time. He has taken only 3 briefs for that day. So he would be right in saying that I am prepared for the matter, I'll charge for it. But as a client, of course, you'll say the hearing was not effective, why should we be charging? So there are several issues. I try to be flexible in the way we bill in the firm. There's no hard and fast billing structure. So that builds a relationship. It could be for one client, it could be hourly billing. For others, it could be a stage-wise mandate. For various stages, we can give a figure. For other clients, it could be lump sum billing. So these are ways we try to build a relationship so that the client or the GC knows that what is come to the firm, there's an openness. We are not taking him by surprise, because otherwise, like I said, especially in litigation, there's a even for me, I can't predict, and nobody can predict how long a matter can go on. So the GC should not feel that the firm is overcharging or delaying the matter. So these are very serious concern. I don't know. I'm certainly don't have the answer to all of this.
No, actually, it's very interesting because it's nice you mentioned this. Indian law firms generally also, we don't follow that pen down culture, which is very common amongst UK and US firms if bills are not paid on time. Of course, I have empathy for those firms because a lot of the work they do is for international clients. So you cannot actually send a runner over to the office to collect. So I can see why they have always this anxiety about collecting on fees. But it's interesting you mentioned budgeting because then what I'll do is I will go straight over to Jasleen because Jasleen has that rare honor of being a general counsel of a big four accounting firm. And pretty much everybody in your organization is big on budgeting, big on accruals, and they're very keen in KPMG, I'm sure, to always understand what is the cost of a particular transaction. So how do you manage a legal budget given what Sanjeev mentioned, that a lot of things, non-effective appearances, all kinds of cost overruns even in transactions. How does a general counsel go about managing budgets when everybody around you is pretty much a CFO material?
So on that, I also have the benefit of being a litigator for many years. So I think I have a perspective from both sides. I've been asked this question, how to manage the budget, and from clients, and I talked to, that's why I never ask this question to my law firms. Because you can't. Sanjeev is right. You cannot predict, at least for litigations, you cannot predict how much you'll end up spending. Though as a GC, you can manage it by deciding which law firm you're going to, which counsel you're engaging, whether this matter merits this law firm and this rate, whether this matter merits 5 people working on it or 2 people working on it, whether I need to take Mr. Sundaram or I need to take somebody who was designated last week. Those are the only ways to manage a litigation cost. But to ask a law firm to give you an estimate, to say this is my budget, apart from if you're doing very run-of-the-mills, if it's a 138 or it's some volume work of consumer matters or something like that in which you agree on rates. But if you're looking at high critical matters, I would never ask. And I would never go back to my management and say that this is how much it's going to cost you. I could have an estimate in my head, and basing that estimate, I may choose to engage with a particular law firm and choose to brief a particular level of counsel. But to go to a law firm and to ask it and give it a carte blanche and say, give me an idea, I don't think that works in Indian litigation system. What Sanjeev said, we've all suffered the frustration of, matter getting adjourned like 6 times in a row, and you paying the full fees for the hearing and the senior and so on and so forth. So I think it's more a question of deciding what is critical, not treating all matters alike, deciding what is critical, deciding where I need to spend, where I need to pull back, and taking a little bit of ownership for those responsibilities yourself. Because I know it sometimes one doesn't want to. It's easier to just say, I will brief this person and I will take the topmost counsel, even though I know that matter is going to get adjourned, or I don't need the topmost counsel for this because I don't want the risk of somebody turning to me and saying that you don't take those choices. So those are difficult choices and they are brave choices. That's the only way I feel you can actually manage a budget.
Absolutely. In fact, just coming back to that lead partner conundrum. So Pooja, it's very interesting that, I think Sanjeev and I both agree that we should maintain the relationship and make sure that we are always front and center in front of the client. But from a law firm perspective, it's also an uncomfortable truth which came out in the report that when these key partners move, most of their clients move with them. So, and you would have seen this a lot in your career as well, that, that the law firm is supporting you, you had a great relationship with them. What can the law firm as an institution do more to prevent such kind of client attrition? So from a general counsel, so far we are all talking about things like costs, quality, which is very individual centric. But what can the institution of the law firm also do to say that, hey, okay, fine, buddy, you're going to another law firm, but I am very happy with this firm, I feel this firm is also an extension of my organization.
Sure, Ravi, that's a very relevant question. And, the whole business profile is changing. There's a lot of transformation. There are a lot of technological advancements, a lot of regulatory changes. And what a law firm can invest is, of course, as many of the GCs have said that, they are even ready to pay extra or pay a premium to, work again with a lead partner they've already worked with. But the way a law firm can invest is, understanding the business profile of the clients, understanding the risk profiles also, because there are a lot of risks that organizations are tracking, and it's very pertinent that the law firm understands what your business is and what are the risks that you are dealing with. Another aspect is that, in my view, it goes beyond just the GC and the lead partner. It is the other members of the law firm, as well as, like some of the others have also pointed that it is within the entire legal team. What is the comfort of the other legal team members also with the law firm members that they are working with. It's most of the time, where the big stuff we've spoken about, but the small stuff where we day-to-day need some kind of legal advice, and the lead partners or their team members should just be a call away. That's very significant for building relationships, as has been pointed out, like Simranjeet said, trust, referrals, costs, everything can be, we've delved into these aspects individually, but if you sum it all up, that's what formed the basis of developing a relationship, right? And the law firms going an extra mile, say tracking what are the regulatory changes, what are the technological advancements that are happening. If they could just understand, what the business is going through, maybe do some sessions so that you not only build the comfort with the general counsel or their team members, but the business should also have a visibility of the comfort that the general counsel and the legal team enjoys with the law firm. Because most of the time, in many matters, the lead partner or their team members would also have an opportunity to interact beyond the general counsel's team also. So some of these measures definitely will help build the law firms and the institutions.
That is quite interesting. In fact, that takes us into the next finding of the report, which is that nearly 65% of the respondents said that they changed their go-to law firm in the last 2 or 3 years. And part of this was because of diversification of their panel, which happens at regular intervals. But 37% ranked poor service as the primary reason that they changed firms. So this is my question to you, Zubin, because you have recently become General Counsel of Air India, which of course had a huge revolution, if I may call it, in terms of its overall. We've all seen what's happened over the last 2 years in that, and continues to happen in the future. So is it not as simple as saying to a law firm that change the partner concerned, I need a different SPOC? Or is it that if there's poor service, you feel general counsels should change the firm itself? But what is your way or philosophy on this?
Thanks, Avimukt. You've been saving the difficult questions for the end. I'll have to be treading carefully with so many law firm lawyers in the room as to what I say about changing law firms. I think the Air India example is probably unique in some ways, or at least not regular, so that may not be representative in the sense that when you move from a PSU to private ownership, there are a range of changes that take place up and down the organization, and the manner in which you approach external counsel would be one of them, and some of those changes are probably more obvious. But I think in general terms, let me start with the premise that changing law firms is painful, right? So nobody really wants to do it. It's operationally disruptive. It takes a while for the firm that you bring in to come up to speed on and understand your business. There's been some discussion about how law firms have to be commercial, how they have to understand your business. So if you're being changed as a law firm, clearly at the risk of stating the obvious, you've got something wrong, right? And I think some of those aspects you touched on, and some of those are rather obvious in terms of level of service, responsiveness, not meeting deadlines. And rather than focus on those more obvious points, let me just talk about a couple of things that I think, in my experience, law firms could do to avoid this, and a couple of things that they shouldn't be doing as well. I think perhaps an aspect of this is cultural, where if a law firm is not providing a service of the level that the client expects, I'm not sure that the majority of the clients would communicate that very explicitly or aggressively. I mean, obviously there are individuals and styles, but I think the onus needs to be on the law firm to have a certain level of emotional intelligence to read the cues before the law firm is changed. And there will be some, but you'll need to be alive to them. Of all of the law firms that we use, and because of the niche areas that we have, there are a variety of firms that we use both domestically and overseas. A very small proportion of them will actually say to me from time to time, what could we do better? And what are we not doing very well? But there are a few that stand out because they say that. And they say that regularly. They will come and meet regularly and say, what are we getting wrong? Tell me what we could be doing better. I think these are a couple of things that law firms could proactively do to make sure that they're not at the receiving end of a change like that. And there are also a couple of things which, from a client's perspective, are real bugbears that you don't want happening, because you're on the line to your internal clients as a GC, some of whom in the large corporations of today are extremely savvy commercially at knowing their field. And when they're looking for legal support, they're looking for legal support that is as savvy as they are. And I find one of the pitfalls, law firms often fall prey to this, is overcommitting and under-delivering in terms of area of expertise. A number of times a client will reach out to you and say, what experience do you have of such and such? And the usual reaction, because there is a pressure at the law firm end to bring business in through the door, is to say, oh, I've got lots of experience of that, and this is all the experience that I have of it. And you get a list of, if a client looks at that list cursorily, he may not notice it, but a lot of that is actually not bang on the point, right? And that gets exposed very quickly if you're actually engaged in that. And a lot of areas that clients will be reaching out for will be niche areas. They may not be. That's the reason why a lot of in-house counsel are reaching out. There's been talk about how you can in-source run-of-the-mill commercial work, but you will outsource niche areas of work. So it's much appreciated when a law firm turns around and says, actually, you know, we have some experience of that. It's not our sweet spot. This is the experience that we have. If you think it works for you, let us know. Otherwise, you know, talk to us when you have something else. The other thing that is best avoided, and this happens more often than law firm partners might realize, is internal law firm dynamics sometimes affect the quality of your service. Now, these things will exist, but they should always be kept internal and never visible to your client, right? I'll give you an example that's geographically at a safe distance. So about 20 years ago in the London legal market, and London was a market where the lockstep equity partnership model had been tried and tested and existed for decades. Right? About 20 years ago, with American firms becoming more common in London, what the Americans candidly refer to as eat what you kill became more common. And today I can't think of a single major English law firm that isn't following eat what you kill. And when that transition happened, there was a big change in the way partners in those old English law firms started interacting with clients, because it became essential for the partner to be the first point of contact for that client on a new matter. There are similar factors that affect law firms around the world, including in India. And I think it's important for law firms to safeguard clients from any delivery issues on those. And the most relevant example I can give you of this is, and a lot of the private practice firms that I worked in didn't have team structures when I was there. Some of them have moved on to having them. The teams often operate as firms within firms, and that affects law firms from leveraging on all of the expertise that they may actually have sitting in different areas of the firm. And you're doing your client a disservice, but you're also doing yourself a disservice as a law firm if you fall prey to that sort of thing. So I think it's essential that you structure yourselves in a way that presents your best side to the client in terms of drawing on all areas of expertise. And I think putting that best foot forward probably will result, hopefully, in you not being changed as a law firm, and the client will be more the happier for it.
Well, that's very, very good insight. In fact, I forgot to mention that Zubin has also been a law firm partner. So in a way, what he has given us is deep insight into the kind of dynamics that are there on the supply side as well, and why you often have partners behave the way they do. We've seen. Yes, absolutely.
So I think I also have faced this quite a bit in terms of I wanting to expand into the same law firm, asking that, look, this is the issue. So now the concerned partner always would kind of covet that new transaction, even though he or she is not skilled in that transaction. And then they'll say, okay, I'll check back, I'll do my internal assessment, connect you with the right partner, but I keep waiting for that right partner to be connected, and always, meaning at times it's been quite like, so I approached I approached the concerned partner directly, and then there is a whole hue and cry that why did you not go through me? Meaning, so that's a problem. So one interesting thing which you have not raised is, what if the GC changes? So even there is movement within the GC fraternity. So how are you able to retain the client? Meaning, because the client is actually the affected party, the GC has moved on, he is not able to take along all the mandates, right? So same way you have to introspect as a law firm that, look, when I am able to do that.
Thank you, Sanjay ji.
Yeah.
In fact, finally, I get a question to answer here. So, no, absolutely. This is a very strong concern and anxiety amongst law firms and law firm lead partners, because GCs also, to keep on gaining sectoral expertise, they do change, and they often change frequently. Now, there are three ways of looking at this. One way is to make sure that you have multiple points of contact within that organization. That typically larger organizations will have an office of general counsel, you will have assistant general counsels, deputy general counsels. You should maintain a rapport with them as well, right? The second is, which goes back to that point about internal referrals as well as expertise being a very proven aspect, right? So if you are a person who, as Zubin said, is batting outside your depth or showcasing those partners who are outside their depth, then the risk of the GC changing and the new GC completely canning the firm is very high. So showcasing multiple partners of your law firm to the client so that there are multiple points of connect, working with multiple stakeholders within that organization. Indeed, they could be the finance people and all. I mean, only half joking, but sometimes having pending bills is also useful. Having multiple pending bills allows you to be in the system always and keep chasing. But fundamentally, this is a risk which is there. Sometimes we as law firm partners feel, and we always wish the best for our general counsel friends, that if you do move, you should move to better pastures, you should bring more opportunities for us, and the risk is there because every general counsel, I think this came out in the report, you have relationships, and we have to acknowledge that. In the past, we did not. Law firms always felt that general counsels were automatons of a company. The relationship is either with the promoter or with the CFO. Nobody cares about, I think you mentioned legal manager, right? Nobody cares about the legal manager. But no, the legal manager is important. You have real relationships. You also know partners in rival law firms. And we should be mature about that. Only expectation we will have is that the existing matters should continue, and that any new matters, there should be a fair opportunity for the house firm, if I will, to also be able to bid for those matters. So that is the fairness generally that external counsels expect from the new GC in all cases. In fact, one interesting thing which has not been discussed so far is the role of policy. So we now have identified an office of general counsel, But a lot of companies also have a very large PR policy wing. And interestingly, they also have legal budgets, right? And often they also have their own preferred law firm relationships to work with. Now the catch is, general counsels have to ultimately be where the buck stops in everything legal. But the policy people also have their own advisors. So I have a very good friend and buddy, Rakesh Pusti of OYO, and I have seen him, overall, he's also been in Max before this, that he is a person who can very deftly navigate policy and law as if there is no difference between the two. But what do you think about this trend of policy departments having legal inputs, and where do you see general counsels cooperating and working with them? How should a general counsel, and anybody in this room, one of the younger GCs, how should they react if there's a new policy person who joins the organization and then says that, hey, I have my own lawyer to go to? If somebody could give Rakesh a mic, that would be very useful.
Thanks, Avi. I think I have a small point to share before this on the other topic. I think we talked about changing counsels, changing law firms. Why to change? Right? I think we at times miss that change is necessary. Change could be a constant, but change is not necessary, and I personally experienced that. We feel that a new relationship cannot be built. You have to build a new relationship. I've done that myself, and some of them in this room. I had the greatest relationship with the top 3 firms, but I thought to actually start a new relationship with a new firm who incredibly worked in the company that I work today. And most importantly, one of the best anecdote to this is, did you introduce your CXO group or management team to the law firm? And do they have the same amount of comfort that you have in your law firm? And they have that. And third point, if I'm not around, will they take the same decision for the company as a law firm partner? I think I'll leave these 3 thoughts for choosing the law firm part. I think from a policy standpoint, it is supremely important that the GC leads the strike. There will be always public policy person in the company. You have to work together. It could be, you may not be the leader, but the influencer is somebody has to be the GC. Because you understand the absolute nuance in the organization. You talk to the business day in, day out. You feel the pain and to do. I'll give a classic example. I worked for Max Healthcare. Raghu, this is, we worked together on this point. Thanks for partnership. Indian medical system does not allow bike ambulance. So you only have 4-wheeler ambulance. The Ambulance Act actually has only 4-wheelers. And we did have a different department of public policy, somebody will go and influence, but we actually thought to work together. I personally went to make a representation to the government saying, we would like to do 2-wheeler ambulance. And there is no provision in the law today, so the government also can't do anything for you. So before even they start thinking about that and say this will require change in law and blah, 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 and so many stories about it, it will go for assembly and then I don't know, talk about that. We only made a small proposal, allow us to test it. And the test actually, we showed them the result, the test result actually saved 15 lives over a period of 1 month, because the ambulance could not go into every nooks and corners of a Patparganj or a Paharganj or Karol Bagh or so on. So the ambulance actually worked through bike. They only said that we will not switch on the batti nahi jalayenge. Hindi mein hi bola unhone. Because that's the law, you can't break it. So that's the creativity and innovation that has to start only when you have the pain. If you are working in the hospital, you have understood the problem of the mortality in case of an accident and not able to serve them in time, that's where the innovation starts, and that's where the solution starts. So the GC has to be a part of the solution, not dissecting the problem. That's where I feel that they have to be the leader in that progress. Thank you.
Fantastic. Thank you for that. So I think we are pretty short on time now. I think there's a lot of program left. So with your kind permission, if I think we can close this panel. It has been very interesting. Okay. So 30 seconds only.
30 seconds, yeah.
45 seconds.
So in fact, 2 points I would like to raise. Rakesh has rightly pointed out the role of GC. Ultimately, it goes to the role of GC. When you are the business enabler, certainly you understand that pain of the business and then can suggest to the organization. So which we are saying. Then, Sanjeev, I will touch your point. In fact, that is also very close to my heart. Recognition of GC, right? We are discussing from last couple of years. GCI is working hard on that. ECOS is, I can see so many members from ECOS here. ECOS is also working on that. And I think the time has come when the pain of business, GC can understand. And this statutory recognition to the GC certainly will increase that level of GC up to the highest level in the organization. That probably time has come and we have to work together. All of us have to work together on that to achieve that. That's the only thing I want to say.
Fantastic. Absolutely. Absolutely. Thank you very much. So, Lavanya, over to you. I think we are. I hope do we have a lot more time? 2 minutes. Oh, that is interesting. So okay. So since you have a very captive audience, I think what I will do is I will just open up the floor to everybody, and we can have a floating mic. So anybody has any questions from the panel or any suggestions?
Just one, maybe couple of comments. One on the legal budget part. Of course, I completely agree that in litigation it's very difficult, especially in the current context when arbitrations go till curative petition. It's really getting very difficult to predict with precision, and forget about precision, even with imprecision. But of course, at some level, for your internal governance, you do have to predict. And that's where I think law firms and counsels, it's kind of a difficult discussion with the law firm that a GC has, trying to explain why do I need the average or the estimate of number of hearings or the hours of discussion or conferences that you would need, because ultimately I have to prepare a budget, give it to my finance, my management, get an approval, and then only I can issue the engagement letter and engage. So that's one aspect where I think law firms, partners who are mature enough, they understand this very well, and they are very, I think, receptive. And
that's very interesting. In fact, I just recently got an email from an in-house lawyer who pointed out that in the US, his law firm gave him a detailed budget for a class action lawsuit, which actually granularly mentioned everything that it will take, of course, with healthy assumptions, right? Yeah. But in India, as you know, you also have honorable senior counsels who add a lot to the budget, and arbitrators, and arbitrators, right? And 3-person arbitrations. So you do have those kind of risks in India, and you cannot predict what the other side will bring to the table. So sometimes, you know, like as Parvesh mentioned, that you can have more firepower. The GC on the other side could think that this is a high-stakes matter for me. It may not be for you, but it may be for them. And they might bring a very distinguished senior counsel, in which case your law firm will tell you it could be dangerous for you to just go with your existing arguing counsel. So those kind of big variables happen. So I think if it's a healthy relationship, a lot of budgeting can be solved. And I think, as Zubin also mentioned, that feedback loop should always be there. So it should never be that a law firm feels, transactional, to use that word, that we won this, so we actually, budgeted 50 lakhs for this, we got 1.5 crore, that's a big win. You should feel the empathy of the client, that if a client budgeted 50 lakhs and ended up spending 150, that is a disaster in their minds.
Absolutely. This is
in fact,
one.
We expect this from law firm that you should help us and behave a client lawyer, right?
Yeah.
So in one example, we have 3 members panel of arbitrators, and it was decided that the fee will be fixed for 1 session per day, right? And when they were writing this procedural order, they have kept it like before lunch 1 session and after lunch another session. So 3-member arbitrator, 2 Supreme Court, 1 High Court. I'm not naming that. So that cost me double per each day, right? They are keeping at 11 o'clock, 11:30 after tea, 11 to 12:30, then 1.5 hour lunch, and 1 hour after lunch session. So both the lawyers from my side and the government department side, they didn't agree to go back to the tribunal to say that because it was agreed for 1 session, you are charging for 2 sessions. So in that case, we expect from our lawyers probably to put forward this request to the arbitrator or somewhere where we can save our budget.
I'll direct this to Sanjeev, because he's the litigation partner in the room. So Sanjeev, is this common, what Parvesh mentioned, or do you think that this was an exceptional experience that he got.
If they propose that they'll be charging an X amount, and then usually you don't disagree with that. Ideally, the idea behind this schedule was to make arbitrations cost effective. There is a time frame established, there is a fixed fee structure based on the amount involved. So if most of the problems would be solved insofar as the arbitration is concerned, cost concerns, if they go by the schedule, but especially now sir is here, I don't want to say anything more, but we've seen arbitrators don't usually go by the schedule. That is the problem. Yeah. And if you object, the other side doesn't object, then you have a feeling that the award may come against you. So
no, that is absolutely true. In fact, arbitrators are also human beings, and ultimately, you as a litigator will have to play to win. So every soft thing, every dissatisfaction, just like as I mentioned, if you are very aggressive with a GC or a client on billing, that will impact the relationship. So in an arbitration, if you do anything which even has a 2% chance of impacting your relationship with that arbitrator, that in itself could be an ethical issue for your client. It could become a disservice to your client as well. Do we have any other questions from anyone here? Yes.
For I have a concern more than a question. I have been trying to decode this hourly rate breakup. So if ever I make this mistake of going with the hourly rate model, the breakup that I receive is us getting charged even for their internal discussions, and the entire team joining for one simple call where it can be handled by maybe the partner or a senior partner. So how do I resolve this? And you know, I have changed many law firms just because they refuse to sort of, you know,
No, this is
address my concern.
This is actually very valid. In fact, anecdotally, most of us who lived in Delhi would remember in the past there was this meters in the auto rickshaws, right? So when you had the meter down, that chap would take you all over for a Delhi darshan, right? So you would see everywhere, and by the time you reach your destination, you would realize that you probably spent 3x the time that you would have taken otherwise. And then you see the meter, and of course the meter sometimes runs fast. I don't say that law firms do that on timesheets. That would probably be fraud. But it is an issue, right? As a GC, you do feel that I wish if I could just say that I need a destination charter. I want to go to the airport. I don't want to go by the meter. The problem is this, right? And I think Sanjay ji also mentioned this, that you don't want to pay lawyers to train themselves on your dime, right? And a lot of clients have that feeling. But you do want lawyers to invest time in your matter, because law is such a subject, it is so subjective, unlike say medicine, right? Where if a doctor is billing by the hour, you'd be like, don't do that. You just bill by the operation. And indeed, some parts of legal field are like that. There's a lot of matters which you can actually squeeze and give a very clear estimate. But if it's an M&A mandate or a litigation, you are playing to win. So if, for example, a lawyer sees representations and warranties or indemnities, how much rubber to burn, right, is sometimes incentivized. And of course, I will be an apologist for the early billing model. So it is incentivized by the fact that there is a meter going on. Sometimes the client actually does want the lawyer to take adjournments, for example, right? You mentioned non-effective appearances. If you're on the defendant side, it is a known tactic in India, right? That you want to take adjournments. Your client should be happy. If I've taken a stay order, even on the plaintiff side, you got a stay order. How is it in your interest that your lawyer should expedite the matter after that? You got the stay, right? So in that situation, then to turn around and say this was a non-effective appearance, the lawyer also feels weird, right? Because I can make it effective for you, right, if you want. But that would mean giving the other side the opportunity of being heard. So similarly, sometimes lawyers talk a lot in M&A transactions to tire out the other side. They're trying to tire them out. They're trying to make sure that the lists are so long, those discussions are so long that the other side says, okay, fine, I'll go with what you're saying. But you made a very valid point, and in our firm also we discourage this. Internal discussions should not be built.
Exactly.
Nobody likes the idea of seeing that there was a call. I've often had GCs get scared if there's a call with 5 lawyers on the law firm side, right? So you get scared, right? There are 5 lawyers, that means there are 5 meters turning simultaneously. And then those 5 meters go away into another conference room and brainstorm, right, quote unquote. So you don't want to see that. So ideally what we try to do is we have maker-checker principles, where you want to make sure that even if another person is checking what the maker has made, that is our cost, right? So that is our cost, that is our training cost, right? If a senior associate still has the need to show to a partner something which an associate has drafted.
Thank you.
It's also partly marketing. It's partly marketing.
So, in answer to your question, you should push back and say, don't charge me for internal discussions. And you should say that I will not pay for more than 2 people on a call. You can have 5 people.
I've tried doing that, believe me.
But if you push back enough and if you change, things will happen. I have had that. I actually, when I was a law firm partner and I worked essentially on hourly billing. I don't think I've done more than 2 or 3 lump sum matters in my life. But the only reason my bills were never questioned were I never had more than 2 people on a call, and I didn't charge for internal discussions. Probably I charge for other things which the client saw value in, and I think you have to push back. It's like I said, a lot of this is that you have to be brave enough to push back.
And one thing
Thank
do
you.
Also, I've seen some MNCs do this. You have an outside counsel policy, and you put in a lot of stuff there. You'll be surprised that a lot of law firms don't read that. And then when the timesheet comes, you say, hey, I never allowed you to have 3 people on a call, right? So you can actually try to trick the lawyers with a detailed OCP where you put in stuff. I've seen OCPs saying that I will not pay for a fresher, right? So you can have the fresher, that's your training time, right? Sanjay ji, I'm not giving any ideas here, right? Please, you should encourage the young lawyers. But the point is that, you can put a lot of stuff in OCPs, which will start a conversation with the external law firm at that point, right? Thank you very much, everyone.
So, round of applause for our wonderful chairperson and all our panelists. Thank you so much.